So, good afternoon, everyone. And this is Soxai 298, Gender and Sexuality. And our lesson for today is International Events, Instruments, and National Legislation on Gender. So, sa report na to, we will be discussing some key international events and some key international instruments on gender, as well as national laws on gender as well. And along the way, we will also be discussing a few cases in briefly na may kinalaman sa gender. Okay. So, the outline of this report is, first, we will be discussing international events and instruments. Second, third and fourth, we'll be discussing national laws, but they are I categorize them into three. First is significant national laws on women. Second is national criminal laws on women protection and gender equality. And lastly, national laws on women and labor. I do not claim that this discussion is exhaustive, lalo na dun sa part ng national laws, because there are actually a lot of national laws covering gender. But I think that these are the most important ones, and they will be discussed chronologically para makita natin yung evolution ng mga batas na ito. So first, I will be discussing international events and instruments na may kinalaman sa gender. So here makikita natin yung iba't ibang conferences, iba't ibang documents that are instrumental in fostering collaboration between countries, and also in the crafting ng ating national laws. Kasi makikita natin later on na itong international instruments na to, itong international events na to, actually have meron silang connection dun sa ating mga national laws on gender as well. No? So, first of these is yung tinatawag natin na UN Decade of Women. So, itong UN Decade of Women ay encompasses 1975 to 1985. And within this period of 1975 and 1985, nagkaroon ng series of conferences which focus on policies and issues that impact women on various areas of policy, such as, for example, yung sa pay equity. Ultimately we ask the question, is the pay, is the salary of men commensurate to those of women for equal amounts of work done? Studies show na hindi sila pantay. Men earn a lot more for the same effort that women do, So medyo malaki yung gap na yan, so that is what they are trying to address. Gendered violence, which is basically VAUC, and violence against women rather. Landholding and other human rights. Makikita natin later on that this hindi lang itong mga ito ang mga primary concerns ng women empowerment, but we will be seeing that in the succeeding discussions. It was adopted in December 15, 1975 by the United Nations General Assembly by Resolution 31-136. It consisted of 3 international meetings and conferences in Mexico for consciousness raising, in Copenhagen for creating networks, and Nairobi for the solidarity of women worldwide, along with several regional meetings rather. So here, di-discuss lang dyan yung tatlong conferences. Actually, if you will notice later, meron pang isang conference, but that is not really within the scope ng UN Decade of Women, but it is inspired by that event. No? So, the first one is in Mexico City. It is the first ever UN Women's Conference. And in this conference, na-raise yung ilang issues ng mga kababaihan, gaya ng literacy, vocational training, education, employment opportunities, health, family planning, and other services for women. This is due to the fact that it is in these areas na nagkakaroon ng disparity sa in terms of rights, in terms of entitlements. So ito yung mga tinignan nila under the first UN Women's Conference. Second, in 1980 is the conference held at Copenhagen, Denmark, which aims to create networks, connections between several states, and this conference was used to reflect on the progress made since the Mexico City Conference. So, di ba nagkaroon ng unang conference sa Mexico City, tinresh out ko ano yung problems. In the second conference, tinignan ko ano na yung progress. So, they identified key issues that prevent women advancement. So, yun, ano ba yung pumipigil doon sa hindi pagkakaroon ng advancement ng mga kababaihan? For example, is yung lack of political will ng mga decision makers in a certain state, or yung shortage ng mga kababaihan sa decision making positions. Kasi it matters if the leadership has women in them, no? Lalo na if it's pantay, it's fair, kasi it has an impact on yung decisions that they make. Kasi I think the main premise there is someone cannot really push for for something na hindi complete yung experience niya about the issue. So I think yung the fact that women can contribute to policy making, decision making, is an important aspect of women empowerment. And finally is yung 1985 conference, which is in Nairobi, Kenya, a celebration of solidarity and achievement. In this conference, na-produce yung document na the Nairobi Forward-Looking Strategies for the Advancement of Women. So itong document na to, na-create siya on the third conference, which is actually an action plan to think about what's beyond 1985. Kasi of course the fight for women empowerment should not and did not end in 1985. So this document lays down strategies in order to advance the causes of women beyond 1985. And what we can see in the succeeding slides is that hindi nga naman natigil talaga sa 1985 ang women empowerment, ang push towards women empowerment. One of these, actually two of these are yung tinatawag natin na CEDAW, or yung Convention on the Elimination of All Forms of Discrimination Against Women, the Declaration Against Violence Against Women, and the Beijing Platform for Action. Okay? So, let's go first dun sa CEDAW. So, the CEDAW, or the Convention on the Elimination of All Forms of Discrimination Against Women, was adopted in 1979 by the UN General Assembly as an offshoot then nung UN Decade for Women. Kasi kung titignan natin, it is still within the 10-year or within the decade of women actually. So, it is described as the International Bill of Rights for Women. So, dito nakalagay yung mga karapatan ng mga kababaihan in the international and the national scene. So, this CEDAW comprehensively addresses women's rights within all aspects of life while providing opportunities to each state to address its shortcomings. So, as you will see later doon sa case ni Karen Vertido, itong CEDAW na to, parang flags yung mga violations nung karapatan ng mga kababaihan at binibigyan ito ng recommendations ang mga estado on how they will address yung mga shortcomings nila when it comes to the rights of women. And it also defines what constitutes discrimination against women and sets up an agenda for national action to end such discrimination. So, all forms of discrimination dinefine ng CEDAW at naglagay din dito ng national strategy to end such discrimination. Parang binigyan niya ng framework kung paano ang mga bansa, kung paano i-end yung discrimination. Okay. So what are the commitments of states under the CEDAW? First is to incorporate the principle of equality of men and women in their legal systems, abolish all discriminatory laws, and adopt appropriate ones prohibiting discrimination against women. So, isa sa mga commitments ng Pilipinas under the CEDAW is to incorporate the principle of equality of men and women in the legal system. So, kung titignan natin, maraming mga batas na ginawa for the benefit of women, or actually for benefit of equality between genders, between and among genders actually, para at the end of the day mawala yung discrimination. The point naman of why we have the CEDAW is actually not to parang make women as the superior gender, but actually the point is to equalize, to balance out yung discrimination that exists in society. So it's more of a corrective measure to prevent discrimination. And we will see that in the succeeding slides. Next is to establish tribunals and other public institutions to ensure the effective protection of women against discrimination. And finally, to ensure elimination of all acts of discrimination against women by persons, organizations, or enterprises. So, yun yung main commitments ng mga tao under the CEDAW, ng mga states rather under the CEDAW. So we will be discussing a case which originated from the Philippines, involving this CEDAW, which was a petition that was ruled by the Committee on the Elimination of All Forms of Discrimination Against Women. So, here's the case of Karen Vertido versus the Philippines, which is the first CEDAW case that reached the Committee on the Elimination of All Forms of Discrimination Against Women. This is an international tribunal. So, the facts of the case are, Ms. Karen Vertido is the executive director of the Davao Chamber of Commerce and Industry at the time that the alleged rape happened. In March 29, 1996, Vertido was raped by a certain JBC. The decision of the CEDAW, the decision of the CEDAW in this case did not mention the full name of the perpetrator. No? So JBC is the president of the Davao Chamber of Commerce and Industry. So JBC offered to take two women colleagues home. Nakasama niya dun sa after a meeting. No? One of them is Karen Vertido. So after dropping off the first woman sa bahay nila, JBC grabbed Vertido's breast while in the car and did not drop her home but was driven to a hotel. And then after which, JBC dragged her to a hotel room. Hinila niya pasok ng hotel room si Vertido. So nung nakarating sila sa hotel, ang ginawa ni Vertido was she locked herself in the bathroom. She stayed there for a while, and after that, she tried to escape nung feeling niya hindi tulog na si JBC, or she's not hearing any noise already. She tried to escape, but JBC pinned him down and she lost consciousness. So pinned down siya ni JBC, tas nawalan siya ng malay. So na-rape si Vertido while she was unconscious, no? So, but eventually she regained consciousness and was able to free herself. So nagising siya habang nare-rape siya. And then eventually nakalaya din siya, no? So Vertido immediately underwent medical legal examination within 24 hours mula nung ma-rape siya. And she reported she reported to the police within 48 hours. So, immediately, nag-file agad ng complaint itong si Vertido sa police. Tapos nagpa-medical legal na rin agad siya in order to preserve whatever evidence can be preserved from the case, from the rape incident, no? On April 1 in 1996, she filed the case but was dismissed by public prosecutors. Nag-file siya ng case pero dinismiss ng mga prosecutors, kaya walang information that was filed. However, in the same year, October 24, inappeal niya yon sa DOJ, and the DOJ reversed the dismissal of the case ng mga prosecutors. So, binigay yung information. In November 7, the information was filed in court, and after 80 days, JBC was arrested. Inaresto si JBC. This was, it had major coverage sa TV and sa radio. In 1997 to 2005, doon ganun kahaba yung trial ng case na to. So, imagine from 1997 to 2005 ang trial ng isang rape case. What are the reasons? The lawyers resorted to dilatory tactics, dinelay yung hearing, and 3 judges inhibited. Nag-beg off sila from the case. So, imagine what could have been the reason bakit nagkaroon ng 3 inhibitions ng judges, and it took so long. So 1997 to 2005 is like around 8 years, no? It dragged on for 8 years. So what is the ruling of the regional trial court dun sa case? The accused JBC was declared not guilty. For what reason? First is the court did not understand why the author had not escaped when she allegedly appeared to have had so many opportunities to do so. Ang sabi ng court is, sobrang dami niyang opportunities for escape, pero hindi niya yun grinab. And sabi doon, should the author really have fought off the accused when she has already regained consciousness and he was raping her, the accused could have been unable to proceed to the point of ejaculation, in particular bearing in mind that he was already in his 60s. Ito siguro yung isa sa mga pinaka-controversial na content nitong decision na to, So the court is of the idea na hindi mag-ejaculate supposedly yung matanda if she struggled to get out of yung kanyang yung position ni Vertido. And ang isang ninote pa ng court is that he's already in his 60s, so it is physically improbable for him to consummate yung rape, But so what's the move of Karen? So the next move of Vertido was to file a petition with the Committee on the Elimination of Discrimination Against Women. So, one might ask, bakit hindi siya nag-appeal ng kanyang case? Interestingly, the legal system of the Philippines does not allow appeals for dismissed criminal cases. Why is that? Kasi under our constitution, nakalagay doon that a person cannot be twice put in jeopardy of conviction for the same offense. That means that once that a person has been tried for once a valid judgment has been rendered and that judgment dismissed the case, hindi pwedeng ulit masubject to the same jeopardy or to the same danger of being convicted ang isang tao because it is a violation of his constitutional right against double jeopardy. So the only remedy that is available to Vertido in the local legal system, in the Philippine legal system, is a petition for certiorari under Rule 65 of the Rules of Court. Now this petition for certiorari is really not a very it is not an advisable na remedy because it is really hard to prove. It is really hard to have a case annulled under this kasi they must prove that the judge act whimsically, capriciously, and really without actually parang doing anything about the case, but the case clearly there had been hearings ganyan, and there is basis in jurisprudence and law yung naging decision ng RTC. So there's no way that there's no way that a petition for certiorari will be granted by the Supreme Court, So that parang out of the question na yon, yung sa certiorari na yon. But again, appeal is not available. So yung next move niya is to go to the CEDAW. Okay? So what happened there? Anong mga naging arguments ni Karen Vertido doon sa CEDAW case niya? First is that yung violation ng gobyerno ng kanyang karapatan to non-discrimination, and yung failure nila to respect, promote, and fulfill her right caused revictimization. Kumbaga parang naging biktima siya ng rape, and then again she was victimized because of yung kawalan ng aksyon ng gobyerno doon sa kanyang non-discrimination. And according to Vertido, the RTC judge resorted to using gender-based myths and stereotypes about rape that are not really in line with what the CEDAW is about, what the CEDAW is about. So ito yung main arguments ni Vertido, but I will be discussing in detail yung kung ano yung sinasabi niyang gender myths and stereotypes. The first gender-based myth and stereotype that the court resorted to in the case of Vertido nung nasa RTC ito is that a rape victim must try to escape at every opportunity. If you'll remember from the decision ng court kanina, it said there na she had so much opportunity to escape pero hindi niya ginawa. But contrary to this myth, the CEDAW, and actually if you think about it in the practical sense, rape victims do not always try to escape because it's not simply a physical it's not simply a physical restraint, but it has a psychological aspect to it. Fear, intimidation, mga ganon. And this can lead a person to freeze under the circumstance, So the claim of the court that the rape victim must always try at every opportunity to escape is not really it's not really something that is factual, and it is a gender-based myth, So second is to be raped by means of intimidation, that the victim must be timid or easily cowed. One misconception as well about rape is that only women who are timid or easily cowed are raped, Pero apparently hindi, Maraming cases that despite struggle, hindi pa rin nila kaya physically yung mga nang-rape sa kanila, or even if they can, sometimes they freeze under the situation gaya nga nang na-mention ko kanina, So it's not really fair to call a victim timid or easily cowed just because they were raped by intimidation. 3. To conclude that a rape occurred by means of threat, there must be clear evidence of a direct threat. It was also proved in the court decision that there was no direct threat kay Vertido during that time, Kasi hindi nila actually the reason why this was the decision is that kasi hindi naman daw na prove na barrel yung kinukuha ni JBC noong tinatry siyang nung dinadrag siya papunta sa hotel, etc. So there's really no direct threat there, Pero again, uh, you don't need to prove, for example, na merong direct threat na tututukan siya ng barel or whatever, because someone who is in a powerless position might think of something na pag parang bubunt ka lang ng kukuha ka lang ng something sa pitaka mo or something as pagkuha ng barel or whatever, no? Hindi kasi siya it's not simply about proving the fact that that JBC was actually pulling pulling a gun from his holster. Pero the point there is, it is Vertido's parang view na teka, kumukuha siya ng barel. So that is already an intimidation. That is already a form of threat. Next is the fact that the accused and the victim are more than nodding acquaintances, makes the sex consensual. Okay. Yung inference ng court that they are really close is an indication daw that the sex is maybe, or there's a chance that the sex is consensual, or the sex is consensual dahil magkaano sila, dahil they are close to each other, mga ganon. But actually that is not also a reasonable an inference, given na kahit na sobrang close kayo ng tao, that person is still capable of raping someone, no? That person, especially someone he or she is close to, diba? In fact, sometimes people arrange to be close with someone just to have sex with them, and if someone does not agree, well, they resort to rape, no? The fact that they are close does not automatically mean that the sex is consensual. To add to that kanina, actually even spouses now can be even a husband can be charged for marital rape, no? So when a rape victim reacts to the assault by resisting the attack and also by cowering in submission because of fear, it is problematic. Kasi hindi daw consistent yung ginagawa ni Vertido na nung una nire-resist niya yung attack, no? Tapos eventually nag-cower siya into fear. At ang sabi ng court, that's problematic. Actually, it's not, as I mentioned a while ago, rape is not just physical, it's also psychological for the part of the woman. And there can be discrepancy between yung kanyang yung kanyang responses in a different time frame. And hindi dapat consistent na lagi siyang nagre-resist. Or hindi tamang i-infer na ganun dapat na consistent siya, no? Hindi dapat, it's not really problematic as contrary to what the court is claiming. Next is, the rape victim should not have resisted the sexual attack if the accused were able to proceed to ejaculation. Sabi doon, the claim of Vertido was that she tried to resist. Pero daw, bakit daw nakapag-ejaculate pa yung matanda, no? Again, yung fact ng resistance, whether it is present or not, should not determine whether it's sex or it's rape or not. The point there is, was there consent, and that this will be pointed out in the decision later. It's not really about the struggle, it's about the consent, no? And 6, it is unbelievable that a man in his 60s would be capable of rape. Siguro this is the most ridiculous part of that decision, because a man in his 60s could very well be capable of rape, and this was affirmed by the Sedao decision later on. So this is a myth, obviously, no? So ayan, what is the Sedao decision here? So according to the Sedao decision, in short, ang sinabi niya is, the state party, which is the Philippines, failed to fulfill its obligation to Karen when she sought help doon sa kanyang rape incident, and therefore violated the rights of Karen under Article 2C, F, and 5A of the the CEDAW. So, ano ang recommendation ng CEDAW? First is that for vertido, she must be given compensation commensurate to the gravity of the violation of her rights. So, sabi kanina, may violation ng karapatan ni Karen, and therefore the state must compensate her for yung gravity ng violation against her. And as general recommendations, there must be the state must take effective measures to ensure that court proceedings involving rape allegations are pursued without undue delay. Kasi kung titingnan natin, sobrang haba nung inabot nung trial nung case ni Vertido. It took 8 years for her to get yung justice na kailangan sa kanya. Hindi pa nabigay because yun nga, not guilty pa yung decision. And to ensure that all legal procedures in cases involving crimes of rape and other sexual offenses are impartial and fair and not to be affected by prejudices or stereotypical gender notions. Kasi nga, the court resorted to gender myths and stereotypes in rendering that decision. So, ang suggestion ng CEDAW is dapat i-eradicate natin itong stereotypical gender notions natin. In order to achieve this, sabi ng CEDAW, a wide range of measures are needed targeted at the legal system to improve the judicial handling of rape cases, as well as training and education to change discriminatory attitudes towards women. Okay? So, ayun, yung sabi ng CEDAW on the case of Karen Vertido. So, let's go now naman doon sa Declaration on the Elimination of Violence Against Women. So, this is another document which siguro ang pinaka malaking contribution nito is yung definition niya ng violence against women. Sabi dito is any act of gender-based violence that results in or likely to result in physical, sexual, and psychological harm or suffering to women, including threats of such act, coercion, or arbitrary deprivation of liberty, whether occurring in public or in the private life. So, dito nanggaling yung definition ng violence against women, and later, if you will, we will see that this is adopted in the national legal framework natin, But interestingly, there is something additional doon sa ating VAUC law. So, sabi dyan, ang VAU o violence against women can happen even in the public or in their private lives, So may tatlong klase ng violence against women according dito sa sa declaration na to, which is yung physical, sexual, and psychological violence occurring in the family. So ito yung sa private, physical, sexual, and psychological violence occurring within the general community, which is the public, and physical, sexual, and psychological violence perpetrated or condoned by the state wherever it occurs. So be it private, be it public, basta it is condoned by the state, it is a type of physical and psychological violence. Yun yung mga types ng vow according to this declaration. And according to this declaration, state agree that they should condemn violence against women and should not invoke any custom, tradition, or religious consideration to avoid their obligations with respect to its elimination. So sabi dyan, hindi pwedeng gawing dahilan para i-tolerate ang vow. Hindi pwedeng gawing dahilan to tolerate vow ang mga customs, traditions, or religious considerations. Of course, this is something easy to say, pero once cultural relativism comes in, medyo mahirap ang enforcement nito in the international scale. So, ito yung basically yung pinaka-gist ng declaration on the elimination of violence against women. So, the declaration also speaks of various types of violence. Like, in the family, pwedeng yung battery, yung pagbatter ng ng husband sa kanyang wife, sexual abuse of children, dowry related violence, rape, female genital mutilation, which I think will be a discussion subsequent to this, So basically, that's genital mutilation that is a part of culture of some African states. So yun na, dun na pumapasok yung sinasabi ko kanina na cultural relativism. And other harmful practices, non-spousal violence against women, like yung hindi naman yung asawa but the other members of the family are violent towards a woman, and everything related to exploitation ng, for example, when the husband is the one exploiting the person for prostitution. Within the general community is included dyan ng rape, sexual abuse, harassment or intimidation at work or school, trafficking of women, and forced prostitution when it happens in the general community. So this hindi lang naman exclusive yung mga yan sa within the family. So it can also happen publicly, and within the general community. And yung state sanction is any of these, whether internals within the family or within the general community, as long as it is sanctioned by the state, it is violence against women perpetrated by the state. Okay, so ito lang, these are just examples of violence against women that needs to be condemned. Another document that we will be discussing is yung Beijing Platform for Action. Itong Beijing Action for Action is also an offshoot of the UN Decade of Women. Itong document na to is a landmark document for advancing the rights of women and gender equality worldwide, agreed during the 4th World Conference on Women in 1995 in Beijing, China. So, di ba, kung isipin natin kanina yung 1975 to 1985 ang UN Decade of Women, pero the international community thought of adding another conference, which is the Beijing Conference, and etong Beijing Platform for Action ang naging product nung conference na yan. So, the international community came to a consensus and agreed to a comprehensive blueprint of commitments supporting the full development of women and their equality with men in 12 areas of concern. Dito naman sa Beijing Platform for Action, in-identify yung 12 key areas kung saan medyo problematic ang equality between among men and women. So, in the next slide, I will be discussing yung key areas na I will be enumerating yung 12 areas na ito. So, these are the 12 key areas. Women and poverty, education and training of women, women and health, violence against women, women and armed conflict, women and the economy, women in power and decision making, institutional mechanisms, human rights of women, women and media, women and the environment, and the girl child. So ito yung mga key areas that needs attention according to the Beijing Platform of Action. So the Beijing Platform for Action affirmed the principles that would govern future actions and strategies for women, and firmly set in place an agenda for empowering women by integrating their concerns in national plans and policies. And you will see later that itong mga that these areas were also part ng mga pinag-focusan ng mga iba't ibang batas natin in the country, which aims to empower women in general, no? According to the Beijing Platform for Action, government and the UN agreed to promote gender mainstreaming as a strategy to ensure that the gender perspective is reflected in all policies and programs at the national, regional, and international levels. So, kung mapapansin natin sa mga agencies, especially in the executive department, gender mainstreaming is a buzzword kung isipin na nga rin, ginagawa natin ito sa mga offices natin, sa mga agencies natin, itong gender mainstreaming na to, and this is because of our commitment under the Beijing Conference and the Beijing Platform for Action. So these are just a few examples of the documents and events that happened in relation to the plight of women and their rights. So next we have the significant national second part of the report, which is the significant national laws on women. So first of these is the Women in Development and Nation Building Act. This recognizes the role of women in nation building and the fundamental equality before the law of women and men. So nakita na natin yung parang color of yung international yung influence ng international conferences doon sa mga batas natin, to ensure that it also aims to ensure that women benefit and fully participate in development projects as recipients of foreign aid, grants, and loans, and provides that women must be equal with men as to their capacity to act, such as in contracts and access to credit and insurance coverage. Kung mapapansin natin dito, development ang focus niya, no? And this is actually the framework nung WID na discuss last meeting. So it regarding sa foreign aid, sa grants, sa loans, sa contracts, insurance coverage, kailangan pantayang opportunities for men and women in participation in these development projects. It accords equal opportunities for appointment, admission, training, graduation, and commissioning in all military and similar schools of the AFP and the PNP. So dito sa RA 7192, dito yung pinakaunang time na na-recognize na mabigyan dapat ng equal opportunity ang mga kababaihan as regards to appointment, admission sa PNPA, sa PMA, commissioning of all military or similar schools related to these agencies. And the NEDA is the responsible agency in ensuring the women's participation in development. Bilang ang NEDA naman ang in charge sa overall national economic development ng strategies ng bansa natin. So that is RA 7192. But years later, nagkaroon ng codification ng parang some compendium ng mga batas on women, which took the form of the Magna Carta for Women. Magna Carta of Women rather. Magna Carta of Women, which is RA 9710. So ano yung Magna Carta of Women? First, we discuss bakit ganyan yung title. Hindi siya Magna Carta on Women because that yung word na Magna Carta on Women is parang detached siya dun sa kababaihan, Kumbaga, nagiging subject lang doon yung mga kababaihan. The same with for Magna Carta for Women, kumbaga parang it is parang it is from the perspective of a man or the community in general, at binibigay niya ito sa mga kababaihan kung for, So, but this was named rather as Magna Carta of Women because it takes ownership of the narrative. Yung mga kababaihan ang nag-take ng ownership doon sa charter na ito, sa Magna Carta na ito, sa batas na ito. Kumbaga, ito yung comprehensive na women's human rights law sa Pilipinas that seeks to eliminate discrimination through the recognition, protection, fulfillment, and promotion of the rights of Filipino women, especially those belonging in the marginalized sectors of society. So, in RA 9710, kumbaga it is a comprehensive law, women's human rights law. It is comprehensive in a sense that it incorporates yung mga entitlements under other yung mga rights under other laws at kinolekta sa isang instrument. It is a Magna Carta because it is kumbaga it governs a lot of aspects of being a woman in the Philippines. So, yan. What are the salient features of the Magna Carta of Women? Minamandate dito that there must be an increase in the number of women in third-level positions up to 50% in the private and public, and in all levels of development planning and program implementation. So in the planning and implementation of programs, I think this is a vision. This is the vision of the Magna Carta of Women, that eventually the management of development programs will be split between men and women in equal proportions. Dito rin sa Magna Carta of Women, unang na-mention ang special privilege leave for women for 2 months, 2 buwan na leave with pay for women employees who undergo surgery caused by gynecological disorder. So, kung meron kang gynecological disorder, by gynecological disorder, we mean any health issue regarding the reproductive organs of a woman, including the breast. So pwede ka mag-leave for 2 months with pay if you are to undergo surgery sa iyong gynecological areas, provided that they have rendered continuous aggregate employment service of at least 6 months for the last 12 months. So kung nag-render ka ng at least 6 months, 12 months in a 12-month term, you are entitled to 2 months of special privilege leave for women. Ito ay para sa mga gynecological disorders na aayusin through surgery sa mga gynecological areas. Next is non-discrimination in employment in the field of military, police, and other similar services, including yung pay increases, additional benefits and awards based on competency and quality of performance. Kailangan pantay-pantayan, lalaki man o babae. So in the military, police, and similar services, kailangan may mga kababaihan din. So, you cannot be discriminated against by reason of your being a woman. Next is equal access and elimination of discrimination in education, scholarship, and training. So, dapat tinatanggal ang discrimination sa education, scholarship, at training. And because of that, hindi pwedeng mag-expel, hindi mag-readmit, or mag-prohibit ng enrollment ng mga babaeng estudyante and faculty by reason of their pregnancy out of marriage. So hindi pwedeng gawing ground yung pregnancy niya out of marriage for her to be discriminated against when it comes to expulsion, readmission, and prohibiting enrollment sa mga schools, because there are schools which, especially those with the religious mandate, that expel students or prohibit the enrollment of students or do not readmit students because they got pregnant out of marriage. So that's discriminatory, and according to the Magna Carta of Women, this should not be tolerated. Next is non-discriminatory and non-derogatory portrayal of women in media and film. Naging perennial problem 'yan sa Pilipinas, yung parang yung portrayal ng mga kababaihan sa media at film ay naging masama. So tinanggal dapat tanggalin yung mga ganyang portrayals. And equal status must be given to men and women on the titling of land and issuance of stewardship contracts and patents. This is another area where where equal status must be given to men and women. So ito yung mga salient features ng Magna Carta of Women. The Magna Carta of Women is really long and substantial, pero due to the lack of material time, I can only discuss so much. So that is Magna Carta of Women. Next is yung Rape Victim Assistance and Protection Act. This is the one that we were talking about in class last time. So the Rape Victim Assistance and Protection Act requires the establishment of a rape crisis center in every province and city that shall assist and protect rape victims in the litigation of their cases and the recovery. So ito, parang yun nga, gaya nga sabi nga last time, this para itong one-stop shop for rape survivors, itong Rape Crisis Center is a one-stop shop where services of doctors, police officers, prosecutors, and social workers can be availed of in one setup. What is the reason for this? Bakit kailangan iisa lang? This is to avoid revictimization of the clients. Gaya nga nung nasabi dun sa case ni Vertido, yung revictimization, kasi naging biktima na siya, and then eventually she has to repeat yung narration over and over sa mga iba't ibang agencies for her to get assistance, for her to get legal, social, economic assistance from different agencies of government. Kaya to prevent the trauma, to prevent yung revictimization ng biktima, kaya nagkaroon nitong Rape Victim Assistance and Protection Act. Ano ang assistance na binibigay? Psychological counseling, medical and health services, medical legal exam, free legal assistance or service sa mga rape victims kung kailangan, assisting rape victims in the investigation. This is on the part of the PNP to ensure the privacy and safety of rape victims. So dito, especially even in court decisions, kung ayaw nung tao na i-reveal yung kanyang name, yung privacy niya, hindi yun kino-compromise, pinapalitan ng pangalan. Providing psychological counseling and medical services whenever necessary for the family of the rape victims. Developing and undertaking a training program for law enforcement officers, public prosecutors, lawyers, medical legal officers, social workers, and barangay officials on human rights and responsibilities, gender sensitivity, and legal management of rape cases. Adopting and implementing programs for the recovery of rape victims and establishment of women's desk in every police precinct. These are itong mga assistance na to are designed para ma-prevent yung revictimization as well as matanggal yung discrimination against women who are victims of rape, kasi in the Philippines unfortunately yung babae na rape na, siya pa yung nahihiyang lumabas sa society as if she is kumbaga parang as if she is any less kapag naging victim siya ng rape. And sometimes even law enforcement agencies, even law enforcement officers discriminate against rape victims, no? Minsan hindi pinapansin, minsan they try to they try na pagkasunduin yung mga yung parties when clearly the woman does not like it, or marami silang shortcuts just for them to avoid doing the hard work in processing the case. That is an unfortunate reality that happens now, pero also yung itong rape crisis centers natin, hindi pa naman ito fully implemented until now. Hindi pa rin fully established itong rape victim assistance and protection through yung rape crisis centers, kasi hindi naman lahat meron. Based on report, I think there are only 3 to 4 regions who have these rape crisis centers, which is unfortunate, given that it is very important. Next is we have perhaps the one of the most controversial and highly divisive piece of legislation in recent history, yung Responsible Parenthood Bill and Reproductive Health Act of 2012. Same energy siya as yung anti-terror bill natin ngayon. Same energy, same noise that it created in the media, ang itong Responsible Parenthood and Reproductive Health Act of 2012 is parang in response doon sa growing population ng Pilipinas, and doon sa commitment natin under the Millennium Development Goals and ultimately the Sustainable Development Goals to reduce our population growth. Kasi parang despite yung current reminders, hindi naman nababawasan ng population, and the parang decision and the parang solution of the legislature to this problem is to enact a law that will allow parents and basically the general public to have yung a wide range of reproductive health trainings, information, and yung reproductive health products that will help them plan their families well. Ano? But the main objection over this itong policy na to is on the distribution of artificial birth control methods, mostly from the religious sector. I remember during this time, sobrang daming this is one of the times sobrang daming infographics on Facebook, which says na about which parang nagpapakita ng mga studies, mga ganyan, and Bible verses, especially from the religious sector, parang condemning itong act na to of distributing artificial birth control methods to parents, and to yung spouses rather, and yung general public. Kasi ang promise nitong batas na to before was it will be yung reproductive health products like condoms, mga ganun, and health services will be readily available sa mga tao when they need them. And even after its passing as a law, naging subject pa siya ng mga kaso. Most notable are these two Supreme Court decisions. Imagine these are two separate na Supreme Court decisions on just one law. First is on the matter of the case of Imbong versus Ochoa on the constitutionality of the RH law. So kinestyon yung constitutionality ng RH law, and the decision of the court is it is constitutional, yes, pero merong 8 provisions of the said law na declared unconstitutional. Partly unconstitutional, parang as a whole it is constitutional, the main tenor of the law is constitutional, pero there are just some areas there na dineclare as unconstitutional. Next is the case of Diocese of Bacolod versus Comelec on the Team Patay Team Buhay tarpaulins. Now, ito naman, this was years after, parang 2 years yata after the enactment of the law. So here, the Diocese of Bacolod, the Diocese of Bacolod, parang nag-post sila ng tarpaulins outside their church that classifies yung mga senators and party lists and parties rather na who are who supported the RH law. Team Patay, yung mga senators na senators na nag-support dito sa RH law na to, like as far as I can remember, it's one of the yung isang pinaka-binash dito sa na to is Lisa Hontiveros, no? She supported the RH law, and yung sa Team Patay na yon, din-discourage ng simbahan yung din-discourage ng Diocese of Bacolod yung mga tao nila to vote for this Team Patay na mga senators or political figures, no? This was questioned in the Comelec and ultimately sa Supreme Court because sabi because it is parang it is an election offense. Kumbaga, 'di ba, meron tayong prohibition against campaigning using tarpaulins. Meron lang siyang specific na height and weight, no? This was questioned in the Supreme Court, and the Supreme Court said it is there's nothing wrong with that. Walang mali doon. So, yun yung case ng Diocese of Bacolod versus Comelec. This is really a hotly debated topic, especially when I was nasa UP na ako nitong time na to. So imagine the uproar. Pero ito kasi I think a majority of the UP Baguio community supported itong Reproductive Health Act. The academe is almost unanimous with this, no? siguro religious sector talaga ang pinakamalaking opposition dito sa reproductive health law na to. So the Reproductive Health, Responsible Parenthood and Reproductive Health Act mandates the hiring of additional nurses sa mga health facilities, ganyan. Nagbibigay ng broad range of modern family planning methods, pero yun nga, some of it are basta ang malinaw doon is dapat hindi siya abortifacient or something that aborts a child na nabuo na, mga ganyan. Ayun, kailangan necessary lang na kailangan merong support din for couples who have infertility issues, mga ganun. There must be procurement and distribution of family planning supplies, integration of responsible parenthood and family planning component in anti-poverty programs, conduct of age and development appropriate reproductive health education, including the formulation of curriculum for use by public schools and may be adopted by private schools. Pero up until now, ito hindi pa yan nag-materialize hanggang sa ngayon. We have yet to see yung sex education and responsible parenthood education modules from DepEd, and wala pa rin naman there is a push from private schools, pero hindi siya systemic, no? Another thing is there must be provision of PhilHealth benefits for serious and life-threatening reproductive health conditions. And there must also be capacity building of barangay health workers by disseminating information and providing training programs to LGUs. And there must be pro bono services for indigent women in private and non-government reproductive healthcare service providers. But according to the Supreme Court here, this provision, yung pro bono services, yung mandatory for private and non-government reproductive healthcare service providers, is hindi na siya it was declared unconstitutional because of the conscientious objector doctrine that was raised in the 2018 2012 Responsible Parenthood and Reproductive Health Act. Yung sa dahil sa petition with the Supreme Court. So hindi na required, but if you wish to provide pro bono services, and if you do not object doon sa to reproductive health, you can provide, pero hindi na siya mandatory. Okay, so this law is important to me personally kasi this was the first question I had to answer in my first subject ng 2018 bar, the case of Imbong versus Ochoa, and I think this is very memorable kasi it's something that is a landmark legislation, but unfortunately was declared partly unconstitutional, yung 8 provisions nga na nabanggit ko kanina. So we proceed to national criminal laws on women protection, gender equality. So first criminal law that is in relation to yung women protection and gender equality is yung anti-rape law. The anti-rape law amended the revised penal code in several respects. First is it expanded the definition of rape to include rape through sexual assault. So yung traditional rape kasi is that there must be a touching of the penis and the vagina, there must be penetration in order to be considered as rape. Yun yung traditional conception ng rape under the law, no? Pero na-amend na yun to include sexual assault. So ano yung sexual assault? It is yung inserting the penis into another person's mouth or anal orifice. So or any instrument or object into the genital or anal orifice of another person. So yung pag-insert ng penis sa bibig at sa anus at yung pag-insert ng instrument or object sa genital area at anal orifice ng isang tao can be considered already as rape through sexual assault. Okay? Kasi sobrang restrictive yung traditional rape na kailangan may penetration. Also, in this law, the rape was reclassified as a crime against person from a crime being a crime against chastity. So, anyone in charge of law enforcement can validly file a complaint on behalf of the victim because it has become a public crime. Dati kasi, it is a private crime in a sense na yung party offended lang ang maaaring mag-file ng case for rape. Pero since it became a public crime, anyone who is in charge of law enforcement, not necessarily the victim herself or himself, can file the case for rape. No? And here, kung mapapansin nyo sa expanded na definition ng rape, hindi na lang babae ang maaaring maging victim ng rape, but also men and LGBT and all genders actually. So, kasi pwedeng sa anal orifice, pwedeng sa mouth, or pwedeng even din inserting of objects, inserting of any object or instrument sa genital and anal orifice of another person, not necessarily a woman, can be considered as rape. Okay, how is rape committed under this new law? No? First is, ito yung traditional rape, which is by a man who shall have carnal knowledge of a woman under any of the following circumstances. Carnal knowledge, by the way, is sexual intercourse. That is just a flowery term. Ano? Again, rape is committed by a man who shall have carnal knowledge. Take note of this: a man. Only a man can commit traditional rape. Who shall have carnal knowledge of a woman under any of the following circumstances: force, threat, or intimidation, when the offended party is deprived of reason or otherwise unconscious. Remember this, by means of fraudulent machination or grave abuse of authority, when the offended party is under 12 of age or is demented, even though none of the circumstances mentioned above can be present. So first, tingnan natin yung unang tatlo. Force, threat, intimidation, when the offended party is deprived of reason or otherwise unconscious by means of fraudulent machination or grave abuse of authority. So dyan, ano ang sinasabi dyan? Sabi dyan na kailangan merong force, threat, intimidation, kailangan the offended party must be deprived of reason, or kailangan unconscious, or kailangan there must be fraud or grave abuse of authority. Paano kung initially paano kung there's no direct showing ng force, threat, or intimidation, or hindi siya deprived ng reason, or hindi siya unconscious, at hindi siya but there's no fraud or grave abuse of authority, pero the person just chilled when she was attempted to be raped, walang struggle, etc. In that case, that is not considered as rape, unfortunately, ano? And for letter D, when the offended party is under 12 of age or demented, even though none of the circumstances in the above mentioned are present. So here naman, dito naman, regardless of whether there's consent or not, 12 years old and below, below 12 years old or demented persons, automatic rape yon. That is what is called statutory rape. Kahit pa may consent ng below 12 rather, that is still rape because that is statutory. Nakalagay dyan na in short, ang sinasabi niya dyan is a woman below 12 is incapable of giving sexual consent. By any person under, ito na yung rape through sexual assault, by any person who under any of the following under any of the circumstances mentioned in paragraph 1 shall commit an act of sexual assault by inserting the penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another. So kailangan andun pa rin yung instances under paragraph 1, yung force, threat, intimidation, deprivation of reason or otherwise unconscious, fraudulent machination or grave abuse of authority. Kailangan dun pa rin yun. Pero, yun nga, hindi na lang siya directly doon sa vagina ng babae, but even other sexual, other parts of the body. What are the critiques to the anti-rape law? Una, the broadened definition of rape, kahit na na-broaden na yung definition natin ng rape, hindi pa rin siya nakafocus sa aspect ng lack of consent. Kasi doon, kailangan mo pang i-prove yung threat, kailangan mo pang i-prove yung force, threat, or intimidation, or kailangan mo pang i-prove na unconscious. But actually, technically, kung iisipin mo kailangan sumentro yung definition ng rape sa lack of consent. Regardless of yung attending circumstances, if there is lack of consent, that should automatically be considered as rape. Pero that's not the case here. Next is the age of sexual consent for statutory rape is very low at age 12. We are one of the lowest in the world in terms of sexual consent. 12. Imagine, you cannot enter into a contract before you become 18, pero you can consent to sex before you can consent to sex at age 12. Imagine that. Masyadong mababa yung age of sexual consent natin. Next is the forgiveness clause is counterintuitive and exposes the survivor to further harm. Ano ba tong forgiveness clause na to? The forgiveness clause under the anti-rape law is kapag pinakasalan nung rape victim yung rapist, yung nang rape sa kanya, considered condoned yung crime, Now this forgiveness clause is counterintuitive kasi because of the pressures of the family, kasi nabuntis ng isang tao, oftentimes yung babae ay napipilitang magpakasal dun sa lalaki, and that is a good thing para sa lalaki kasi wala na siyang criminal liability, and at the end of the day nasa losing end pa rin yung babae dito sa arrangement na to, kasi what if that man is abusive, and that is already established because of yung naging na nga sa kanya, sexual advance, it exposes the survivor to further harm from the person. So those are the valid critique, I think, which I considered valid critiques to the anti-rape law of 8353. Anti-rape law, or RA 8353 rather. Okay, before I proceed to the next law that I will be discussing, I want to ask you what comes to mind when you hear this. So if you're from the same generation as I am, I think what comes to mind when we hear this is the series of sex videos involving Hayden Ko and different women during at that time rather, in 2000, sometime in 2009. So the next law that we'll be discussing is the Anti-Photo and Video Voyeurism Act of 2009. Okay. Actually, if you'll think about it, this is not really just focused on women alone, pero this is a very important legislation that heavily affects women, So what's the context of this law? So this came into existence as a response of Congress to the highly publicized Hayden Ko sex videos with several women in May 2009. Ito yung nagkaroon ng scandals all over social media, which is really young back then in the internet, ganyan. Hayden Ko's sex videos with not just one but several women actually, who are actually prominent din na mga kababaihan. So this law aims to protect both men and women, but is often more beneficial to the latter, as these non-consensual recording of sexual activity usually victimize women or exposes women to more ridicule. So ito kasi yun, nagkaroon ng series of hearings in Senate in aid of legislation. Pina-attend si Hayden ko doon in order for them to craft a law that will put a stop to yung itong voyeurism nga ng photo or video. It was also another controversial topic back then, So dito, it prohibited ang pag-record ng videos or taking photos of a sexual act, the male or female genitalia, and the female breast, among others, without consent of the person featured in the material. We will be discussing this in detail maya. So, it also seeks to prevent the reproduction, distribution, and publication of these materials regardless of whether or not the persons featured consented to the recording. Here are the prohibited acts under this law. So, first is to take video or photo of persons performing sexual acts or similar activities, show of private parts. So dito, ang taking of photo or video must be without the consent, without the consent nung tao in order for it to qualify as prohibited act under RA 9995. And they must have a reasonable expectation of privacy. What do we mean by this? Yung pagkuha ng video or photo somehow requires a certain the parties must be expecting that they are private, they are doing it privately. For example, a sex video na private, so considered yun as prohibited act. Pero what if what if it happens in a situation where there is no reasonable expectation of privacy? Example, they are doing sexual act in public, nasa public, under the public eye, nakikita ng maraming tao. Syempre hindi yun covered nito because that is not voyeurism if they are not expecting that you are to be private, or when they are doing live broadcast, 'di ba? Or naghuhubad sila in public, knowing full well na it will be disseminated to the public. So there's no reasonable expectation of privacy there. So the act of taking video or photo must be when they have reasonable expectation of privacy. It's also illegal to copy or reproduce or cause these acts and cause this reproduction or copying with or without the consideration. It doesn't matter kung paano mo yan kopyahin or i-reproduce, as long kahit na walang consideration, kahit na hindi bayad, it's still a prohibited act. Next is to sell or distribute such photos or videos, whether original or reproductions. Kasi this is also included dito sa prohibited acts, kasi at that time hindi lang siya pinasa-pasa through cellphone kasi hindi pa naman usong Facebook noon, or kung meron man if at all, di ba? I think wala pa siya. So pinasa-pasa yan through Bluetooth ng mga tao, internet, links, ganyan. And some people nag-burn ng mga CDs, tinitinda sa mga bangketa, yung sex videos na yan, compiled na sex videos na yan. So, it is also prohibited to sell or distribute these photos or videos. And finally, to publish, broadcast, or cause the publication or broadcast of the same. So, pinagbawal ang pag-broadcast nitong nitong mga photos or videos where the persons are performing sexual acts or showing private parts of persons. So, yun yung Anti-Photo and Video Voyeurism Act of 2009. Next is yung Anti-Violence Against Women and Their Children Act, or RA 9262. Perhaps this is the most one of the most important pieces of legislation about women in the country, If you remember kanina doon sa sa declaration against sa International Declaration against violence against women. Sabi doon, 'di ba, ang violence against women includes psychological, sexual or psychological violence, no? But in our law, in our very law, meron siyang karagdagan, which is economic abuse. So I think this is a very advanced law if you think about it, kasi hindi yun na foresee during that time. Wala tayong commitment na ganun in the international law under the UN, pero we still have it as a law in the Philippines. So what are covered? Physical violence, of course, those involving bodily or physical harm. Sexual violence, those which are sexual in nature, committed against a woman or her child. In this case, woman lang, kasi vow lang munang tinitingnan natin. Psychological violence, affirmation causing or likely to cause mental or emotional suffering of the victim, and yung economic abuse, which are acts that make or attempt to make a woman financially dependent. Yung premise nitong economic abuse is that hindi dapat economically dependent ang babae sa kanyang asawa, because it will be harder for the woman to escape the husband in case she decides to leave because of battery or yung physical, psychological, sexual violence, no? Kahit na gusto niya isama yung mga anak niya, hindi siya makakaalis with her children because nakatali sila sa ama nila in terms of yung finances. So that is the rationale behind yung economic abuse as a form of violence. Who may be liable for vow? Sino mga liable dito? Hindi lang asawa. Legal spouse, yung common law spouse, anyone with whom the woman had dating or sexual relationship with. Ibig sabihin, hindi lang ito lalaki, basta they had sexual relationship or dating relationship, covered sila ng vows, itong anti-vowsy or RA 9262. So it could be anyone, kahit na nag-date lang kayo, magjowa, ganun, covered ng vow yan. Under the law, there are several prohibited acts, pero nag-mention ako ng mga ilan dito na which may be of interest sa inyo. First is depriving the woman of custody to her family. Kumbaga, inilalayo nung spouse or nung partner yung mga anak from the woman, that is for violence or abuse. Yung withdrawal of financial support or preventing the victim from engaging in any legitimate profession, occupation, business, or activity. Kung legitimate naman siya and wala kang strong reason for objection, you cannot prohibit a person from engaging in any profession. Like gusto niya magtrabaho pero ayaw mo because walang maiiwan sa mga bata. That's not a valid reason to prevent the person from engaging in business or occupation. Next is stalking or following the woman in public or private places. Being a spouse or being a partner is not an excuse for one to stalk someone. Destroying the property or personal belonging or inflicting harm to animals or pets of the woman or her child, and causing and attempting to do physical harm to the woman. Tingnan niyo ito. Inflicting harm to animals or pets of the woman is still considered as violence, kasi it is psychological violence Kumbaga, hindi siya directly sinasaktan mo, pero someone dear to her ang sinasaktan mo. So that is also considered as vowsy. Actually, kung iisipin mo, yung vowsy is a very broad it encompasses a broad spectrum of prohibited acts which are considered as violence, no? Even more in fact than other countries. So under the vowsy law also, there is what we call protection order. The protection order is an order issued under this act for the purpose of preventing further acts of violence against a woman. So kung sinasaktan physically or psychologically isang babae, she can ask for protection order from the court. Parang lalo pag physical ipiprevent yung paglapit ng lalaki to the woman and the family. So may tatlong klase ng barangay ng protection orders, yung barangay protection order, which is valid for 15 days kapag mag-apply ka sa barangay at the barangay thinks na merong reason to separate you from your husband for a while for 15 days for physical violence or threatening to physically abuse a person, the woman, pwede 'yon, may 15 days sa barangay. Pwede ring temporary when you file the case at hindi pa na-desisyonan kaagad yung permanent protection order. Meron siyang temporary protection order if the judge thinks that it is needed, no? This is prior to hearing, before ka mag-file ng case sa court. And permanent protection order, this is permanent after due notice and hearing. Kapag nagkaroon ng due notice at hearing, inimbita yung abuser, tapos inimbita for a hearing, tapos nagkaroon ng decision, the court can issue a permanent protection order. This protection order parang prevents the person from going anywhere near the woman for a certain distance, from a certain distance, radius. So hindi siya pwedeng lumapit dun sa babae. So that is the purpose of a protection order. Now, who may file a protection order? Hindi lang yung babae. This assumes that the violence that vowsy is public crime, The offended party can file, the parents or guardians can file, anyone, any ascendant or descendant or collateral relatives, social workers, LGUs, police, particularly yung sa Women's and Children's Desk, punong barangay or punong kagawad, or lawyer, counselor, therapist, or healthcare provider of the petitioner, kung yung mga doktor niya, yung abogado niya, pwede sila mag-file. At least 2 concerned responsible citizens, okay, who has personal knowledge of the offense at na alam nila na nagkakaroon ng violence against the person, pwede silang mag-file ng protection order in court or in the barangay. Other salient points ng vowsy law is violence against women and their children shall be considered a public offense, which may be prosecuted upon the filing of a complaint by any citizen having personal knowledge of the circumstances involving the commission of the crime. So sabi nga doon, tama nga yun, na public offense na siya. Therefore, any citizen na may personal knowledge sa kung ano nangyari can file a complaint against the abuser. Kasi sometimes, kahit na inaabuso yung babae, if financially, most especially if financially tied siya dun sa asawa niya, unfortunately, hindi yun magko-complain, no? Victim survivors who are found by the courts to be suffering from battered woman syndrome do not incur any criminal or civil liability. So ito yung battered woman syndrome that I think I may have mentioned in class before, pero for the sake of discussion, i-discuss ko lang very briefly. If the woman is suffering from battered woman syndrome, or if she is being battered by his husband on a regular basis, paulit-ulit, if she does something to her abuser, she may be exempt from criminal and civil liability. Okay. Next is being under the influence of alcohol, any illicit drug, or any mind-altering substance shall not be a defense. If there is a case filed against a person for violence against women, hindi niya pwedeng sabihin na lasing siya, nagdodroga kasi ako, or I'm taking any mind-altering substance. It is not a defense. Regardless of what you're taking, you can be held liable for vow. So that's I think those are the more important points relating to vowsy law. Another law that protects women is itong anti-mail order spouse law, or RA 10906. Ano ba itong mail order spouse business? It is the business of organizing or facilitating marriages between Filipinos and foreign citizens, no? Kumbaga parang binubugaw yung mga Pilipino natin to be spouses of of foreign nationals, no. There is an earlier law which is yung RA 6955, which is anti-mail order bride law, which is which is specifically addressing women's problems about mail order brides. Pero because of RA 10906, dahil hindi na lang limited din naman sa mga kababaihan itong na to, although mostly babae talaga, pero may mga din, in-include din ng mga hindi babae. And also dahil outdated na rin yung batas kasi ngayon uso na lang sa online na so repealed na yung RA 6955. It became RA 10906. What's the purpose of this? To curb the incidence of Filipinos being abused by their spouses abroad, especially in the 1990s when cases of abuses made rounds in televisions or news outlets. Dati very prevalent yung mga news items na nagsasabi na may mga naabusong mga kababaihan ganyan sa US at sa iba pang mga bansa. And these are usually victims of the mail order bride business na ginagawang business din talaga ng mga ibang Pilipino rin or other foreign nationals, no. So in order to put an end to this, ginawa itong anti-mail order bride law and eventually itong anti-mail order spouse law. Itong later law encompasses even online na paraan ng pagsolicit ng mga Pilipina or mga Pilipino for to be married abroad. So ayan, what are the prohibited acts? Una ay yung matching or offering a Filipino to any foreigner through personal introduction or online. Yung pinakilala for the purpose of having them arranging a marriage for them, ganyan, advertising to any means the matching of a Filipino to a foreigner, inducing any Filipino to join groups whose purpose is to match Filipinos with foreigners for a fee, and use the postal service or any website on the internet to promote the prohibited acts. So ito yung mga examples ng ito yung mga pinagbabawal sa batas, So bawal mag-advertise mag-advertise ng mga ganitong klase ng marriages in social media, no? Bawal din gamitin ng postal service for this purpose. So kung iisipin natin, this is a very important law, especially for women na biktima ng domestic abuse abroad dahil sa kanilang abusive spouses, no? But sometimes if the operation of if the operation is international, mukhang mahihirapan tayo to prosecute them because there is this generality principle and territoriality principle in criminal law na naglilimit sa atin na mga nandito lang sa Pilipinas, those who are living or sojourning in the Philippines are covered by our criminal laws. So, yun, kapag international ang coverage ng operation, that might be a problem. Next is one of these also one of the most important pieces of legislation protecting women, itong Safe Spaces Act or RA 11313. So, it expanded the definition of sexual harassment in terms of the following. Although, a quick note, hindi niya ni-repeal yung RA 7877. Existing pa rin yan. Existing pa rin yung batas na yan. It's just that meron tayong bagong batas on sexual harassment which is RA 11313. dito sa Safe Spaces Act, pinalawak yung definition ng sexual harassment. Kasama na dito ngayon, dati sa dating batas, workplace, educational and training environments lang ang covered ng sexual harassment. Pero ngayon, all private and public spaces, even online, are covered by Safe Spaces Act. So sa kalsada man, sa kalsada, sa mga bars, sa Grab, sa mga pampublikong sasakyan, sa mga tren, sa school, sa workplace, ganyan, lahat yon covered na, even online. Okay? Next is, the next difference is, kung sino lang nakaka-commit ng sexual harassment. Dito, may be committed by a person in authority or one with moral ascendancy. Usually, lalaki lang yan, under the old law. Pero now, anyone can commit sexual harassment regardless of gender and status. Anyone, whether may moral ascendancy o wala, kahit tambay din sa kalsada, kahit subordinate mo pa, kahit sino actually, basically, can commit itong sexual harassment na to. And finally, yung isang pinaka-importanteng distinction is yung it is limited yung sa old law, limited siya in terms of acts punished. Pero dito sa bagong batas, mas malawak na ang mas malawak na ang acts na covered ng batas na to. Makikita natin later. So, ano yung mga prohibited na acts under this law? Dati, hindi covered itong mga to, pero ngayon, meron na. Covered na siya ng Safe Spaces Act. Like, cursing, wolf whistling, yung pagsipol, catcalling, leering, kahit na yung malagkit yung tingin sa'yo, taunting, pursing. Siguro, i-highlight ko na lang mga importante, yung unwanted invitations, yung tara kape naman tayo or whatever na yung insistent at unwanted na invitations na na-feel ng tao na violated siya, that's covered under Safe Spaces Act. Misogynistic, transphobic, homophobic, and sexist slurs, yung mga mga panlalait, pangutya, for being gay, mga ganon, covered yan. Relentless request for one's personal details, like, Miss, pahingin ng number mo. Kuya, pahingin naman ng number. Those are also covered under this law. Persistent telling of sexual jokes, yung pagjo-joke ng sexual, of a sexual nature, regardless of kung nasaan. No? Invasion of a person's personal space, yung masyado ka malapit dun sa tao, na uncomfortable na yung babae, or na-threaten na yung personal sense of safety niya. So, those are covered by paragraph A ng Safe Spaces Act. Itong per paragraph na to, meron silang iba't ibang penalties. Habang as we go on, mas nagiging mas mabigat yung penalties under this law. So ito yung mga medyo in quotes light na infractions. For paragraph B, for such acts as making offensive body gestures at someone, exposing private parts for sexual gratification of the perpetrator. For example, yung papakita ng mga sexual parts, flashing, ganyan. Pinapakita yung mga private parts, yung pag-masturbate in public, di ba? Nakikita natin yan sa mga there are instances where sa public transpo, kung katapat mo yung lalaki, nakatapat na yung babae, nag-masturbate yung lalaki sa katabi or katapat, di ba? Groping or similar lewd sexual actions, these are covered by RA 11313. And under paragraph C, ito yung mas malala, stalking and any of the yung mga nauna, yung kanina yung sa paragraph B, A and B, na may kasamang touching, pinching, brushing against the body, yung pag talagang pag-brush na ng katawan dun sa tao, no? Or touching, pinching, or brushing against the genitalia, the face, the arms, the anus, the groin, breast, inner thighs, face, buttocks, or any part of the victim's body, kahit walang kahit hindi related doon sa mga paragraph, those are considered as punishable under paragraph C. So mas malawak na siya, mas malawak na yung sakop ng sexual harassment. Okay? And in fact, pwede na yan kahit sa online. If you feel uncomfortable dun sa online, you can always file a case for sexual harassment under the Safe Spaces Act. So aptly, this law is called Safe Spaces bawal ang bastos law. No? Unfortunately, ironically, this was enacted into law at a time na even the chief executive is somehow violating some of these prohibited acts, no? So next and finally, we discuss yung mga national laws on women and labor. So first is yung woman and child labor law. So it is incorporated, it is a labor law. These are labor laws in general na that protect women or give certain privileges for women because of yung differences in the circumstances of women and men, no? So here under the itong women and child labor law, ilang beses na tong ilang beses na siyang na-amend. So this is the current version, pero I still called it RA 679, although may mga later versions na yan. As a general rule, no woman shall be employed in any shop, factory, commercial or industrial establishment or other place of labor. Yung mga ganito, to perform work which requires the employee to work always standing or which involves the lifting of heavy objects. Kapag magbubuhat ng mabigat na mga bagay ang trabaho at it requires a lot of standing, or it requires always standing rather, or to work between 10 o'clock at night and 6 o'clock in the morning the following day. Hindi ito pwede sa mga kababaihan under this law. Although of course there are exceptions there kapag may permit. Pinakauna yan. Another exception is in case of force majeure. For example, na bagyo or na wash out yung warehouse or something, may malaking baha that your strength is needed para magbuhat, mga ganyan. Or when the work has to do with raw materials, pwedeng gabi, ganyan. Kapag raw materials, so talagang yung mga nabubulok na mga materials or kung kailan necessary ang night work talaga, as long as these are not hindi yun yung mga regular work schedules, no? Kung kailangan talaga may for example, may shipment ng something na perishable na kailangan ng night work, ganyan. Yun. Pwede silang i-employ for a short period of time. Otherwise, kung medyo mahaba, kung yun yung regular work nila, they will have to secure a permit from DOLE. The main principle here is equal remuneration for equal work done. So kung pantay ang trabahong ginawa ng lalaki at babae, kailangan pantay din ang sahod. What is the duty of employers under this law? So una, the employer has to provide half-hour nursing time for nursing mothers. Pangalawa is there must be a nursery near the workplace if the employer has 15 married employees at least, no? Next is to provide seats and suitable toilets and lavatories for women and men, and at least 60 hours of noon meals. So ito yung mga entitlements na hindi lang naman about sa men and women, pero yung unang dalawa especially, these are really particularly for women, no? So yun yung woman and child labor law. And finally, let's have a 105-day expanded maternity leave law. So, before RA 11210, the Philippines had the lowest maternity leave in Southeast Asia. Isa tayo sa mga pinakamabababa sa mundo. 6 days lang kasi siya under 7322, which is even lower nung sa earlier versions niya. In-increase siya into 105 days in compliance with the ILO Maternity Protection Convention of 2020 at dahil sa constant pressure from various groups. Maraming women's groups at matagal itong 27 years bago na ipasa ang RA 11210. After 27 years of lobbying, ganyan, tsaka lang siya naging batas. Okay. Ano bang salient features nitong batas na to? First is yung to increase the previous 60-day maternity leave to 105 days, which may be extended by 15 days for solo parents and may further be extended by an additional 30 days optional unpaid leave. So in general, from 60 days before, naging 105 days na siya. Kapag solo parent ka pa, entitled ka pa sa additional na 15 days. And kapag gusto mo na mag-leave ng isa pang buwan, kahit wala nang bayad, pwede pa rin, no? So, yung 105 days na yan, plus yung 15 days na extension for solo parents, that's with pay. May bayad siya. Okay. It includes childbirth, miscarriage, or emergency termination of pregnancy. Kapag live childbirth, 105 automatically, no distinction kung normal delivery or or cesarean section. Miscarriages and emergency termination of pregnancy, you are entitled to 60 days. Okay? It does not require that the pregnant woman is married. Hindi requirement na kailangan may asawa yung buntis or merong tatay known yung tatay nung anak. As long as she is pregnant at manganak siya, or even kahit nagkaroon ng miscarriage or emergency termination, she is entitled to maternity leave law. To maternity leave rather na 105 days. Another salient point is the woman may transfer at most 7 days of the maternity leave to the child's father. Pwede niyang ipasa yung 7 days sa tatay if she wants. Basta in coordination with the employer nung tatay nung bata. Again, not needed na nakasal sila. It's just basta lang ma-ascertain na he is the biological father. It covers all pregnancies without limit. Kasi before, meron dating 4 pregnancy limit under dun sa old law. Ngayon, kahit ilang pregnancies yan, it's covered by the law. It includes protection against discrimination, including demotion or layoff. Hindi mo pwedeng i-demote yung empleyado mo, hindi mo pwedeng i-lay off yung empleyado mo on the basis na on the basis na nag-maternity leave siya. It's a discriminatory act. Now, all of these laws actually, from the criminal laws to yung general women's empowerment laws at itong ngayon yung sa labor related laws and all other women's laws are not really designed to give superior treatment to women, but it is these are instruments to correct yung long history of women oppression, yung long history of unfair treatment to women, yung long history of not giving women the same privileges, sets of rights as men. So, eto mga to, these measures are designed to correct the inequality between men and women in society. And I hope that eventually through these laws, through sa mga batas na to, magkaroon pa ng more laws that will help in equalizing the plight of women and men, both in the legal sense na they are entitled to something, but also in the real sense, kasi the entitlement is one thing, and actually gaining those actually using these rights, actually possessing these rights is just as important, so hindi lang yung rights under the law, pero they must truly reflect yung they must truly alleviate yung plight ng mga kababaihan. Okay, so thank you for listening, and I hope we learned a lot from today's lesson. Thank you.